Welcome to the Cyber Risk Management Podcast. Our mission is to help you thrive as a cyber risk manager. On today's episode, your virtual Chief Information Security Officer is Kip Boyle, and your virtual Cybersecurity Counsel is Jake Bernstein. Visit them at cyberriskopportunities.com and focallaw.com.
So, Jake, what are we going to talk about today?
Hey, Kip. Today we're going to talk about DoCRA, which is the Duty of Care Risk Analysis. It's a risk assessment method that helps organizations figure out whether their cybersecurity controls are reasonable.
Well, that's great because guess what? On our listener survey recently, one of the things they said was, please talk more about risk frameworks, risk management frameworks.
That's good. And I think as everyone knows by now, we really like talking about reasonable cybersecurity programs and controls. And so this will help. And today we have as a guest, DoCRA's inventor and main proponent, Chris Cronin. He is a partner at Haylock Security Labs, and he'll be talking us through how DoCRA works. So essentially, it answers the question that we've been, essentially bantering about for a long time, which is, what exactly does reasonable mean? And we're looking at it from a blend of both of our interests, cybersecurity and the law.
Yeah. So, Chris, welcome to the podcast.
It's good to be with you guys.
So, Chris, you wrote Duty of Care Risk Analysis. I have to admit that this is kind of a new thing for me. Jake, I think, has been working on this already, collaborating in the Sedona conference with you, and I've just recently learned that that it's been adopted, it's being taken up by the Center for Internet Security and in other places. So, could you give us a quick description of what DoCRA is? Just dive a little bit more deeply than we did in the intro.
Yeah, sure. Well, we know that generally this question about reasonable security controls has been a big question for lawyers, regulators, information security practitioners, companies that are trying to get compliant. They're struggling to find a workable definition of what a reasonable control is or what reasonable risk means. So what DoCRA is, it's a way to state what risk is and what reasonable is in a way that is spoken in the native language of all those professions: the lawyers, regulators, information security practitioners. So it's a risk calculus that includes all of the things that each of these professions are interested in getting resolved. So,
well, that's no small thing. That's no small thing, Chris, because any listener to this podcast knows that Kip and Jake don't exactly talk the same language. We don't exactly look at the things from the same perspective. And so this is almost like a moonshot at a Rosetta Stone.
Yeah, I imagine. I'm trying to think of what a species of being has the Rosetta Stone on the moon. It would certainly get me interested in going there to find out.
Well, I'm thinking about 2001: A Space Odyssey, right? And the monolith. Okay,
hey,
so
not bad. Good. Good. So let's actually work that through, because this has been fascinating to me. Is the idea that attorneys and security engineers and business people speak a very different language, and surely it's true, but there's something they all have in common, and it's this idea of a balancing test. And Kip, in Fire Doesn't Innovate, you actually hit on this. But halfway through, you've got a description of how an organization can evaluate its controls
right.
On a sliding scale.
That means he read at least halfway through the book, Kip.
I imagine that he just plopped it right down in the middle and said, all right, there's got to be something here I can bring up on the podcast.
That's where it naturally opened. No, I did read the book. It's actually really helpful in a couple of ways. Later in the conversation, if we come to it, I'd like to talk about the importance of fire not innovating and how it associates with cyber insurance. But the interesting thing I wanted to address now is this way you have on a sliding scale an organization evaluating the strength of their controls. And they might say, my control gives me a certain level of certainty about how effective it's going to be. But then a control can go all the way to the end of the scale where it's actually doing more harm than good, right? It can be disruptive to business, right?
Yeah.
So yeah, and this is a common understanding between engineers, security people, lawyers, regulators, litigators, and businesses. You can have enough or too much of a control.
Definitely.
Yeah, go ahead. Yeah.
Yeah, I was just going to affirm that. Thank you for reading my book. I really appreciate it. And yes, that's what I was trying to do, is acknowledge that unlike money, you can have too much security, and there's got to be some way to flag that when you find it, and then figure out how to dial it back. And since you read my book, Chris, you know that what I tried to do in the book and what I try to do with my customers is strike a balance between the purely qualitative and the purely quantitative.
Right.
Because in my experience, neither one of those extremes delivers consistently good results. And more importantly, when you talk about business leaders, and I think lawyers and cybersecurity people might be the exception to this, but when you talk about business leaders, the people who actually make the decisions about how much risk we're going to accept, how much budget we're going to allocate, by and large, they are decision-making engines. They want to make as many decisions as possible. And so when you slow them down to explain new stuff to them that they don't understand, it really messes with their ability to make decisions, and they get cranky. Yeah. And so I try to meet them where they are, which is why my book looks the way that it does. But that doesn't mean that I don't believe that there's a place for FAIR or for all these other risk assessment techniques. I just think you've got to choose the right one for the context that you're working in.
Yeah, absolutely right. And this is exactly what we were striving for in DoCRA. And when we were working with Center for Internet Security to develop their risk assessment method based on DoCRA, that's exactly what they were bringing to the table as well. And Jake, you can't succeed as an attorney, whether you're doing litigation support or strategic advisory or regulatory support, unless you figured out something that makes sense to all parties, right?
That's right, and I'm thinking as you two are talking about this, how important it is to have something to point to when we are trying to describe reasonable, because the core legal concept of the quintessential reasonable man is helpful in a lot of tort-based contexts. Tort being your kind of typical slip and fall or negligence case, and the duty of care is at the core of those negligence cases, right? That is, negligence is you had a duty of care and you violated it. And so what's really interesting is that I suspect you did not choose duty of care risk analysis out of at random. I'm sure there was you did that on purpose, because duty of care has a lot of legal meaning. And just to kind of bring it back slightly to the discussion moments ago, Kip, you and I call it 9 and 10 as a when there's too much security. Another way of saying that, interestingly, is unreasonable security. And we normally say people normally think that having an unreasonable set of security controls is when you're not doing anything close to enough, but it is just as accurate to say that your controls are unreasonable if you've gone way too far.
Absolutely. And the biggest reason for that is because people don't respect the controls. They work around them, and you end up in a 3, like you're unreasonable, but you think you're reasonable. Like you have this false sense of security. You're living in the security bubble where you think everything's perfect, and behind your back, everybody's violating everything, and you have no idea what's going on. And that's why that's so dangerous from a practitioner's point of view.
Right.
Absolutely.
Yeah, exactly. And then to make sure that anybody who's involved in the risk discussion, either in operating a safe organization, in evaluating whether there was some kind of negligence after a breach, everyone in that conversation needs to come to agreement on what we meant by risk. And this is one of the big challenges that we were trying to address with DoCRA. And so far, and Jake, you've seen this with some of the conversations we have with Sedona conversations, which we don't go into any detail about until the publication's been released. But we can at least say that people come to a risk discussion with a vague understanding of what risk means, and not an equal understanding of what it means. And there's usually some consternation. And then when you explain the principles of duty of care risk analysis, then all of a sudden a bunch of heads nod and say, okay, yeah, that makes sense, because everyone's interest is covered. Yeah.
And that's right. And so, I guess the next part of the conversation is, how is DoCRA different from what people already do? And what I mean by that is that, as a practical matter, businesses aren't out there implementing controls that hurt their ability to do business just to adhere to some kind of standard, right? They're almost always negotiating down their controls in some fashion, so that they can operate. Nobody wants to be at a 9 or a 10 if they know, as long as they know they're at a 9 or a 10. And I think you nailed it, which is, what is risk? And I'm curious. Talk a little bit about what we see organizations doing, and how that might not actually hit the bullseye on risk assessments at all. And just as an example, gap assessments, audits, and maturity assessments, or a vulnerability scan. A lot of people might think, oh, okay, I did risk assessments because I did a gap assessment, or oh, I have a SOC 2, so I'm good, right? I think it's more complicated than that. So why don't you talk about that?
Yeah, no, you're exactly right. And this is where we see a big problem, right? So, and we'll get to the commonality here in a minute, but let's first establish what we mean by risk analysis. We're always looking for some kind of probability or the likelihood. We're trying to quantify or qualify the foreseeability of a problem occurring, and then the magnitude of that problem occurring. And we want to know if I've got things in their current state, and I know what's happening in the world, I know bad things can happen, how likely is it that one of those bad things could happen in my environment, and who gets hurt and how much when it does? And we find that when we ask those questions about specific information assets, specific controls, we can have a fairly good estimate, even through an estimated guess from capable people, about how to prioritize risk that way. If I've got a database of my visitors who come in and out and they leave their fingerprint, and I don't secure it because I didn't consider that PII, and it's on a third-party desktop application that isn't connected to anything else, I might say my likelihood of something happening is really low. The impact, depending on who gets the information, could be very high. A bunch of names and fingerprints could be used for other stuff. So it's just thinking through the likelihood of harm. So let's first lay out that this is what we mean by risk analysis, and why it's different from a gap assessment or an audit.
Exactly. So an audit is, so I think to define these terms, an audit is, okay, I'm saying that I have implemented and used these controls. I want you to audit that statement and tell me, basically affirm that my representation is true. And that's it, right? That is all an audit does. That is all an audit is meant to do, right? A gap assessment is, based on some external standard of some kind, we think that there is, we have holes in our system, but neither of those are a true risk assessment. And I think, we should talk briefly about what are the risk assessments out there, and how do they, what are the principles and what are the practices? So,
yeah, before we do that, Chris, I would like to have a sidebar here, hopefully very quickly, about likelihood. So, as a practitioner, I have a real problem calculating likelihood. I think it's an incredibly slippery slope, and here's why. What I've noticed is that risk managers bring their personal risk appetites and personal risk tolerances into their work. So if I skydive on the weekend and scuba and race cars, then the likelihood of something bad happening to me is minuscule. It doesn't matter what forum I'm in. I could be at work, or I could be doing one of my high risk activities. I mean, I just don't see it. In contrast, if I keep all my money under my mattress or in a mayonnaise jar buried in my backyard, everything looks like it's going to kill me. And people bring these attitudes into their work, and it's completely unreliable. And so I have taken the approach dominantly that I don't even discuss likelihood with my customers unless they bring it up, because it's just too hard to school them on this and calibrate them. It completely derails the conversation. And what I find is that senior decision makers love gap analysis. They understand it. I don't have to explain anything to them, or very little. And so while it doesn't really measure up to the the true definition of a risk of a risk analysis. That's the approach that I take. So I'm curious, what do you think about what I just said?
Yeah, well, you're exactly right. You're exactly right. This is this is an area, likelihood or probability is an area where there is a lot of variability in how people approach the question, and that can make risk analysis really meaningless or biased or idiosyncratic. And what we try to do with risk analysis. So when we wrote DoCRA, we were not saying we think DoCRA is better than NIST 800-30. It's better than ISO 27001. It's better than FAIR. It's better than Doug Hubbard's Applied Information Economics. We're not saying that at all. We're saying you can use those methods and use them in conformance with DoCRA. So we're not actually prescribing whether you do a probabilistic statistical analysis of probability or you guess. We're wide open. In practice, here's what I do. In practice, I say, let's take a look at a reliable data set that we can look at that might even be available to the public. So if you look at the Veris community database, right? That's a project that was started by Verizon, and they've got a lot of more than 8,000 records of breaches, reported breaches, and what some people thought were causes of those breaches. Now, and then they can break things down by, where the attack happened, who did the attack, was it an insider, outsider, third party involved, what industry were they in, and all this stuff. If you're looking at data like that, it can say, here are things that are more or less common as causes of reported attacks. So it's a vector that's used more or less. It's an attack style that's used more or less. So that might be an input. It's an input that we use, but it might be an input that someone uses to think about how likely something is. Just get public data about what happens more or less. There are other things that we do, like we associate the strength of controls, the reliability of controls, as a counter against the commonality of the attack. So this is where are you a skydiver or someone who puts money under their mattress comes in. We ask, what is the position of this organization? How reliable are their controls to function correctly? And then we match that against how common the attack is, and then put that against a sort of a bell curve distribution or an adjusted distribution to say, what would the resulting likelihood be given the commonality of attacks in environments like this and the strength of those controls? So
and I think that approach
there
works
are ways to do this.
Yeah, and I think that approach works much better with larger, more sophisticated organizations as opposed to medium-sized and smaller companies, which ironically have all of the same cyber risks pressing down on them as very large enterprises, but they just don't have the sophistication and the means and the method. And I've had a really hard time in my experience. I've crashed and burned multiple times trying to bring more sophisticated methodologies to less sophisticated management teams. And maybe it's because Kip's not good at that. Maybe somebody else would do a better job. But I have rarely seen success. Trying to do that.
Yeah, don't be too hard on yourself. This is actually a really big challenge in the industry, and anything I've seen people do is idiosyncratic, outside of what FAIR does and what Doug Hubbard does. Now, Doug Hubbard's methods are very likely out of reach of a small, medium-sized organization because it takes a lot of effort to even set up probability models that match a company situation, right?
Although I do want to tell you, I've read Doug's books and I've talked with him, and I love what he does. Yeah, but I just don't know how to bring it to people.
Yeah. I've worked with Doug in the field, and we've applied DoCRA using his methods. Yeah, he's a delightful guy, and isn't it funny? You can read books about probability and find them, real easy to read and delightful. But
that's because I'm weird.
That sounds like a fib, but maybe it's true.
No, it's good. But what I want to do is bring this back to the questions, the original questions that you're asking about how this comes into the idea of what a duty of care is. If an organization has the available tools, the personnel, the expertise to do a good job with probability analysis, then they very well may come up with better estimates of what probable outcomes are. But I don't think that's the standard for demonstrating due care. I mean, to get it right. I think, and Jake, keep me honest here, but I think in order to show that you applied due care, you want to show that you did think through how things could have turned out, what the likelihood and the magnitude was how it could have harmed you and others, and how you demonstrated whether your controls were overly burdensome given the risk they were there to prevent. But we're not given points for having been more accurate, but showing that we did the thinking.
That's right. And, there's a really, I think, kind of interesting question here, which is who ultimately gets to decide if someone has met the duty of care. And, we can debate it. Two different sides in a pre-litigation dispute can debate it. But at the end of the day, at least in the US, these types of things will actually be decided. They're a question of fact, and a jury will decide. So, at the end of the day, whatever we come up with, it has to be digestible by a jury of non-specialists. And I think, people routinely make decisions on duty of care in medical malpractice cases, right? But at the same time, you also know that a lot goes into those decisions with the jury. And so I think you're right. It is unlikely that a jury is going to be swayed by, frankly, most forms of quantitative risk analysis, unless the numbers are big. And let me just unpack that slightly. I don't think a jury is going to care if we're off by 5 or 10% in some kind of quantitative risk analysis, right? Let alone, fractions of a percent. They will care if there's a quantitative risk analysis and it's like, 25 to 75%, some really large number that you can kind of understand. The problem with all of this, though, is that in general, people are not good at determining risk at all. People are, how many times have you heard that people are more afraid of flying than driving their car, despite the fact that statistically, you're far more likely to suffer an auto accident than a plane accident. And so, we have to deal with that when we're dealing with all of these different principles and risk assessment forms, and whether it's NIST 830 or FAIR or Risk IT, all of it, they're all just mechanisms to try to get at this question of, did we do enough?
Okay, and that's what I like about DoCRA so far. And again, I'm kind of new to this, but what I like about it is that it's extensible. Right? I think of it as it's a standard that has a plug-in architecture, and you get to decide what kind of risk assessment plug-in you want to
that was
apply.
Quality IT joke there.
Well, I'm sorry, that's the way I think. So and I can do that because I'm the host, right? I'm the co-host anyway. So Chris, all right. So I apologize for devolving our conversation into mudslinging about risk assessment and likelihood, but let's get back on track and let's talk about, so DoCRA is kind of a meta enhancement to whatever risk assessment approach you're using. Is that about right? Or, how would you characterize it?
Yeah. I think that's a good way of thinking about that. It's the idea here is that we see a lot of value and limitations to any of the risk assessment frameworks out there, and the best of them, their authors readily admit to that. So what we're not doing is choosing one or the other. But back to that original question you had about being able to speak a language that everyone understands. If we can talk about risk, saying it's always about some kind of probability of some kind of magnitude of harm, what are the parties in a NIST 800-30 scenario that you're asking about? How about in a FAIR scenario or Hubbard's applied information economics scenarios? And let's make sure that when we're looking at risk, we take care of these three principles, no matter how we do it. We want to make sure that when we evaluate the likelihood of harm, we think about the harm that could go to any interested party. We want to be sure that there's a definition of what an acceptable risk would be. And by acceptable, we mean the level of harm that could come to us, some redressable or correctable harm that could come to others. And we want to be sure that we've evaluated our control using the same method we use to evaluate the risk, so we can compare them and say, did the control make me worse off based on any of those risks? So if we're doing quantitative, qualitative, NIST 800-30, ISO 27005, FAIR, whatever, if we can take those three principles and apply them, we've done DoCRA.
Okay, so let's restate that. So here are the three principles. One, your risk analysis must consider the interests of all parties that may be harmed by the risk. Another way of saying it is you must identify all stakeholders. Second, those risks must be reduced to a level that authorities and potentially affected parties would find appropriate. Another way that I might say that is the risks have to be reduced to the point where a reasonable group of jurors would say you met, would say that you met the duty of care. I mean, that's what we're kind of going for here. And then third, and this is really important, the safeguards that you put into place must not be more burdensome than the risks they protect against. In other words, we're not going to spend $1 million to prevent $1 of risk. Okay, so
that's a great summary, and I can't help but to think about a comparable situation, which I think in this context would probably be the problem of pollution. So if a factory is discharging wastewater into a stream or a river, back in the day in the United States, that was of no concern to the factory. In fact, it saved them money because they didn't have to dispose of that wastewater in any particular fashion. So it was very advantageous of them to just discharge the water in whatever expedient way they could, and they absolutely did not consider the effect on all the stakeholders, which is why the United States had to create an entire agency, the EPA, to put some more structure into that decision-making process. I think conceptually, this is a very similar problem space. What do you think, Chris?
Exactly. And you've hit on one of the most interesting areas of regulatory law that DoCRA grew out of. So back in 1992, Bill Clinton was elected president after 12 years of Republican administrations where people were saying, now we've got a Democrat and regulations are going to go grow. And EPA was one of those things that people were looking at greatly. And what Clinton did within his first year, he signed an executive order, 12866, that said, we're going to make sure that any regulation that goes in place has a cost-benefit analysis to demonstrate whether it's the right regulation. And what's a cost-benefit analysis? It's basically what we encoded into DoCRA. It's certainly that third principle. Whatever we do, we're going to make sure that we've looked at the potential of harm to all people, but we're going to also make sure that the control that we require in a regulation doesn't create an outsized harm to the industry. That there has to be a way that balances everything. And since 1993, Executive Order 12866 has been cited over and over and over again as the basis for other executive orders, because it says regulations may only work if there's a balance between the public interest and the burden of the control that would affect it.
Okay, so conceptually we're in the same park, but I think the approach here is wildly different. We're talking about a non-regulatory approach so far, but do you think it's going to become a regulatory approach?
I think it already is.
I'm not so sure that it's reached the level that DoCRA is trying to get to.
So part of the reason there is that there just haven't been a ton of cases litigated, but I think the FTC, at the end of the day, the FTC, whether they say it outright or not, is applying a form of DoCRA when it says something is reasonable or not. Like it's because there's no other way to really do it. Like we credited Chris with inventing DoCRA, but really he didn't. He restated well for this particular audience what kind of has always been true about kind of harm to others law. This is not necessarily a new concept.
No, it's not. But there's something about the EPA and the way that it works in the United States that I don't think we've gotten to yet, which is environmental impact.
Yes, sorry. Yes, we do not yet have an EPA that for cyber. And what you were going to say was you were about to say environmental impact assessment. That is a formalized version of DoCRA specific to the environment, and most states have them. You always hear about the State Environmental Protection Act and those different assessments that have to be done. I do think that you see that in a few places. For example, the GDPR in Europe has a data privacy impact assessment or data protection impact assessment. That's essentially the exact same thing as what the EPA requires. But there's nothing like that quite in the U.S. yet.
And focused on cybersecurity as
cybersecurity and privacy. Right.
But Chris, do you think that we're on track to getting something like that?
Well, yeah, I don't think so, because we never see a successful federal action, whether in Congress or anywhere, to get a unified understanding of what cybersecurity even is. There's something, but you pointed to something that I've been very intrigued with, and this has to do with, again, why I just sat down and worked out DoCRA to begin with. When you look at the lack of regulatory agency for cybersecurity, you also see a lack of lobbyists in cybersecurity. You don't have cybersecurity lobbyists.
That's really interesting. You don't.
Right. Yeah, and so what's happened is there's when you're looking at regulatory when you're looking at regulations for any industry, we mentioned EPA, but FAA, FTC, FDIC. What happens is that the lobbyists go against the regulators, and they do the regulatory impact assessments, and then the lobbyists go back to their constituents, the industries, and say, this is how you're going to apply this rule. That creates an inefficiency of negotiation rather than a clear risk analysis. In fact, they're doing their cost benefit analysis as a financially interested debate that has something to do with putting money in coffers of litigators who want to, of legislators who want to get back to office. What we're doing with DoCRA is saying, let's remove that. Let's not get into this battle of a lobbyist and a regulator sort of hashing things out. Let's actually use the tools that regulators gave us. Because you look at the HIPAA security rule, Graham-Leach-Bliley Act, and New York regulations from the Department of Financial Services. We see it with CCPA. They're all saying get to risk appropriateness, or get to a reasonable application of the safeguard. So as long as they're telling us, you draw a line on what's reasonable, then all we have to do is articulate carefully what the regulator would expect to see. I want to see that you thought through the likelihood of harm to yourself and others. I want to be sure that you thought through what a non-redressable harm would be, in other words, acceptable risk. And I want to know that your controls are not more burdensome than the risks. And if you show me that, then I don't have a leg to stand on as your regulator. So because there's this void of regulatory oversight and a void of lobbyists sort of complicating things as a negotiation, we still have this gift to define our own level of risk. And I'll just say in practice, before I turn this back over, is that what we've seen with regulators too is that even after a breach, when they're presented this risk analysis, I'm talking about federal and state regulators, they drop their oversight. They say, good, that was reasonable, I'll let it go. That's been the most interesting thing. On a case-by-case basis, regulators just walking away and saying, yes, there was a breach, you showed that your controls were reasonable, done.
That's true. I think that is what's been happening, and I'm not sure what it's going to take other than, people have talked about the cyber 9/11 for years now. I think it would take a cyber 9/11 before there was some kind of more in-depth government action. What do you think, Kip?
I don't think I've got I'm wrestling with this because I'm trying to think of a time when a case where I heard of a regulator saying, you were reasonable, move along, there's nothing here to see.
So you don't hear about those because they don't make the news. The only reason we know they happen is you and I actually did a presentation with an FTC official who told us, yeah, there's been some, there's times when we just drop things, and we drop them when it looks like they have done, they've been reasonable. And here's why, right? Is that as a regulator, what are your options? Okay, your options are you really have two options. You can either settle a case or you can try to win in court, right? The nature of a settlement is the other side is agreeing with you to some degree, right?
Yes. Yeah. And we've talked about this in a previous episode. Why does the FTC settle so much?
We have, yes. We've talked about that exact thing. But in order to win in court, you're going to have to go and make the case that, such and such was unreasonable. Now, if you're the FTC and you find out that someone has done something that you're thinking is somewhat reasonable, your odds of being able to sell a court or a jury that they did something wrong have just plummeted, right? Because we can talk. We've laid out multiple principles. We've talked in depth about a lot of this stuff. But at the end of the day, truly, the most distilled way to say this is: can you convince a jury that the party who let me start over on that. Can you convince a jury that someone did something wrong? That honestly is kind of the shortest way of saying it. And there's a lot of ways to kind of unpack that and right. Build it out, and that's what we've been talking about. But
I assume
that is the core. Go ahead,
Jake. I assume that most regulators who don't take action drop the action because they can't prove that something bad happened, not because they come to the conclusion that somebody was reasonable.
What's the difference, though?
Oh, there's a big difference, I think, but I don't know that's material to this conversation that it's sufficiently different. But that's what I'm thinking about right now.
So let me try to summarize this then real quick, which is I think what you're saying is we've never seen a situation where a regulator has come out and said that is reasonable, and we're not doing, and therefore there's nothing for us to do. You're right. That doesn't happen. What we get,
I would love to see that.
That would be interesting. So there actually is now that you got me thinking about this. That's what the FDA does, right? They basically, the entire process of getting an FDA clearance is essentially affirming a drug or a device's reasonably. And what are the two? What are the main? It's safety and efficacy, right? When the FDA clears something for use, it is making it has basically affirmed safety and efficacy, and we're less concerned about safety in a way, just because we're talking about cybersecurity versus medical devices or drugs. Although obviously safety,
they're converging.
They're converging, right? They're converging. But nonetheless, the idea is, wouldn't it be interesting if there was some affirmative mechanism where you could get clearance? The problem, though, is that fire doesn't innovate.
Damn you, we're using my title against me.
because here's the thing, right? And we've said this before, cybersecurity isn't something you buy, it's something you do. If you think about a drug, right? A drug is the same. When you get approval for the drug, that drug doesn't change, right? If you assuming that you manufacture it the same, and we can gloss over some of this, but fundamentally that drug isn't evolving; it's not changing. Whereas the threat that cybersecurity is trying to protect against is constantly evolving. So how could the best hypothetical FDA for cybersecurity could do would be to say, at this point in time, you're reasonable. That's not necessarily that helpful, because what about tomorrow? I don't know.
Okay, so we actually have positive evidence of something that solves that problem.
Really?
So yeah.
Is it called DoCRA by any chance?
It does. It's kind of funny you should say that. So the state of Pennsylvania released a decision on their suit against Expedia and Orbitz that suffered a breach. Interesting why the breach happened. But there was a breach of information from Orbitz applications that Expedia had acquired, right? And the injunctive terms that the Office of Attorney General Pennsylvania provided for Expedia to behave better were DoCRA principles. So what they're saying is you're going to make sure in your program that you're going to base your controls on a risk evaluation that involves yourself and other interested parties. You're going to have a definition of acceptable risk based on, the foreseeability of a redressable or non-redressable harm, and that your controls will be not more burdensome than the risks. And you're going to evaluate that through a risk analysis, and your program is going to be driven by it.
Okay, Jake, you have to get the citation for that case and study it, because we should do a whole episode on it.
Yeah, I think we probably will. I like that idea. One thing that I have to just point out immediately, though, is that what that injunction does is really not any different than what the FTC consent decrees and decisions say, which is you have to follow this process, because DoCRA ultimately is a process, and that is significantly different from what the FDA does when it approves a specific drug for use and calls it safe and effective, right? That is fundamental. That is a different thing. We're saying, with the cybersecurity context, kind of, at least right now, the best we can do is say, you must follow this process. And then we can audit you to make sure you're following the process. That has potential value, but it's, we can't ever say that, you are reasonable in the future. We could say that you're reasonable right now because we checked and you're following this process, but it is just different. And by the way, I don't think that's never going to change, right? Because
I think you're right.
Because fire doesn't innovate.
Yeah, I think you're right. I think you have successfully convinced me that it wouldn't be all that useful. However, what I do think is interesting here, and particularly in the case that Chris brought to our attention, is the emphasis on how your controls affected other stakeholders. Right? That I think is innovative and necessary and a welcome emphasis in the broader conversation. I like that.
Well, and not just that. I think if you don't do that, you're probably going to fail at being reasonable.
Well, I think as reasonableness evolves, I agree with you on that. But I just don't remember the FTC and any of its settlements, consent decrees really putting a big emphasis on the effect to outside parties quite the way that DoCRA seems to be doing it. I really like this because, as I said, when a factory discharges wastewater with heavy metals into a river, like that's not okay, and it's not okay for people to play fast and loose with information assets that can cause harm to other people if they get out of control.
You're right. And so the FTC hasn't explicitly said that in any of its current consent decrees. However, remember, and we've talked about this, remember the section of law that the FTC is using to enforce cybersecurity. And that would be, it's the unfairness prong of the FTC Act, currently codified at Section 45N. And that actually does say something is unfair if there has been harm to consumers that the consumer couldn't reasonably avoid, and that isn't outweighed by some countervailing benefit to competition or commerce.
Jake, and so it always warms my heart when you cite your sources, man.
I know. But if you squint and then change your perspective, isn't that DoCRA?
But I like it. I just think I like what DoCRA is doing because it's elevating. Elevating that, right? It just hasn't been as prominent in the FTC, although it's there. And now what we're talking about is making it more prominent. And now I can actually go to my customers and say, you can't just think about how this affects you. And here's why.
That's totally right. And just I feel like I need to be really clear. I love DoCRA. DoCRA is everything.
There goes your independence,
right? But I guess what I'm trying to say and what I've been saying is that DoCRA isn't just a nice way of putting things, or isn't a new thing. What it is a nice way to repackage principles that have been ensconced in law for centuries, right?
Well, then we're in violent agreement.
Yes, we are. Let's violently agree some more.
Nobody wants to hear that anymore.
No, and we're also getting. This is also becoming a marathon episode.
It is. So I want to circle back around for a moment because I want to retrace steps and just go back to something that Chris was trying to tell us about, which is the principles, right? That DoCRA has 3 principles and 10 practices, and I don't think we have time to go through all of them right now. We looked at the principles, but Chris, what as we wind the episode down. What final thoughts do you want to share with our audience about DoCRA that you want them to think about when they stop listening to this episode?
Yeah, so that's a great setup for something that's really been on my mind for many years. When I look at risk assessment methods, I almost always see people applying them in a very inwardly focused way. How could I be hurt from this risk? And no cybersecurity problem, breach, or a resulting suit or regulatory action was taken because an organization hurt itself. And when I started on this endeavor to say, hey, we're going to work with organizations to help them evaluate risk, not just to themselves, but to other people, I was a little reserved, and I had to ask myself, why am I feeling reserved about putting someone else's harm in this? And I thought, we tend to think of American organizations, certainly for-profit organizations, as being selfish, self-motivated. And that's just been wrong thinking. We've implemented DoCRA. My company is Haylock Security Labs. We've implemented DoCRA in more than 100 organizations. And organization after organization goes, oh, great, what a relief. And I thought, this is kind of interesting. They see the potential harm to others and the potential harm to themselves together, and they feel relieved. They're not nervous about it. They don't say, I don't want to look at harm to others. And so we started to realize that this problem is first solved at the boardroom. It's first solved in front of the CFO. People who have to try to balance the harm they might do to others to the potential difficult impacts of security controls. That before a regulator ever steps in the room, before a litigator ever steps in the room, the people managing a business are very welcoming of the conscientious decision they've got before them. Am I going to hurt someone more than they should be hurt if I do this? Am I going to hurt myself more than I should if I don't do this? And that has been, I have to tell you, not just heartwarming, it's been very affirming to see organizations, for-profit, nonprofit, governmental agencies saying, yes, this is the calculus by which we want to make our decisions. The myth of the selfish organization that's only motivated by its own purposes, it just disappears when you put this calculus in front of people. It's essentially a scaled depiction of the golden rule. You're going to do unto others as you would have them do unto you. And by the way, they're going to reciprocate. They're not going to ask you to do more than you should to take care of them. So that's been the absolute best thing I've seen from DoCRA, despite the uptake from regulators and litigators and groups like Center for Internet Security. It's been seeing organizations embrace the conscientiousness that comes with looking at what their duty of care is on paper and saying, yeah, we agree to that.
I like the practicality of that. I'm very practically minded, and I think that's super, super practical. I love it. Jake, what do you have to say as we wrap up?
I think that's a really nice way of putting it, I think that most people don't want to hurt other people, right? That's if we wouldn't have a society if that were the case, right? And I think that this. I think that even in the Constitution, Article 3, which is what lays out federal courts, in order to go to federal court, you have to be able to show as a litigant that you've been harmed. And so I think it's completely natural then that when you're doing a risk analysis, that you consider the harm you might cause to others, because that's, even if you're not motivated by pure altruism, that it is in your best interests to not hurt other people. And so I think
if for no other reason, then you're hurting your own market. Exactly.
If for no other reason that if you hurt others, you too will end up getting hurt. And I think that, this is the right way to think about, cybersecurity risks and privacy risks, maybe just as much, if not more so than cybersecurity, if you want to draw a distinction right there. Privacy depends on good cybersecurity, so there's definitely a connection. There definitely is, but I think DoCRA is one. It's a great acronym, but even more than that, it is it's right. It's right in that cosmic sense of this is the right thing to do, and that has a lot of power. Okay, thanks everybody. That wraps up this extended episode of the Cyber Risk Management Podcast. Today we learned about DoCRA, Duty of Care Risk Analysis. It's an approach that helps organizations figure out whether their cybersecurity controls are reasonable, and we did that with the help of our guest, Chris Cronin. Thanks everyone. We'll see you next time. See you next time.
Thanks for joining us today on the Cyber Risk Management Podcast. Remember that cyber risk management is a team sport, so include your senior decision makers, legal department, HR, and IT for full effectiveness. So, if you want to manage cyber as the dynamic business risk it has become, we can help. Find out more by visiting us at cyberriskopportunities.com and focallaw.com. Thanks for tuning in. See you next time.